Hey, gun people. So here's the oral arguments for this case that they just decided in favor of lawful gun owners. And this is why the Supreme Court is so important, that we don't have people like Biden appointing new justices that can't define what a woman is. That's the most recent justice appointed by the liberal left that overwhelmingly supported Biden, and he just appointed a justice that doesn't know the definition of a woman. So this is why the left wants to stack the Supreme Court, because they can subvertly get behind the Constitution and dilute it and make it null and void. Remember, government hates the Constitution because it takes power and control away from them. That's why nobody can support freedom and support liberalism, because liberalism is the biggest attacker against the Constitution. I'm not saying the Republicans are perfect, but liberalism hates the Constitution because they can't get rules. They can't make it into climate change. They can't force you. They can't take all your money. They can't turn us into a communist socialist state because of that pesky Constitution. So anybody who understands freedom and how important a Constitution is would never be against any of the rights that are protected that stops government from interfering with those rights. But let's see what they argue here. If you haven't watched one of these before, the justice that's asked the questions, their face will light up and will be reading in the area of the yellow. So what's being talked about, you can follow along the yellow. Here we go.
This morning in case 2843, New York State Rifle and Pistol Association versus Bruen. Mr. Clement.
Mr. Chief Justice, and may it please the Court, the text of the Second Amendment enshrines a right not just to keep arms, but to bear them. And the relevant history and tradition, exhaustively surveyed by this Court in the Heller decision, confirm that the text protects an individual right to carry firearms outside the home for purposes of self-defense. Indeed, that history is so clear that New York no longer contests that carrying a handgun outside of the home for purposes of self-defense is constitutionally protected activity. But that concession dooms New York's law, which makes it a crime for a typical law-abiding New Yorker to exercise that constitutional right. This Court in Heller labeled the very few comparable laws that restricted all outlets for carrying firearms outside the home for self-defense outliers that were rightly condemned in decisions like Nunn against Georgia. New York likens, but the difference between a sensitive place law and New York's regime is fundamental. It is the difference between regulating constitutionally protected activity and attempting carrying a firearm outside. It is the difference.
So this is the big root of this case is, why can states, liberal left control freaks that hate freedom, why can they limit the Second Amendment on me, but they can't limit the First Amendment? Well, that's not true anymore. They can limit the First Amendment. They're very quick to throw out. The First Amendment is not absolute. The Second Amendment is not absolute. The right to privacy, the right to unlawful search is not absolute. And they constantly chip away at these ingrained things that made this country great. Government constantly wiggles their way in. On First Amendment, they wiggle it into, first it was you can't yell fire in a theater. And then they wiggled in that, well, hate speech. You can't say hate speech. Well, you can't say something that might provoke a violent response. Well, you can't say something that could provoke a riot. You can't say something that offends somebody that may cause them to get upset. So they're slowly chipping away at the first. They've been chipping away at the second for I don't know how many, thousands of gun laws that we have out there. Nobody really knows a good number of gun laws between federal, state, local, etc. They've been chipping away at the right to unlawful search and seizure. They can't do it without a warrant. Well, there's an exception. Well, if you're in a car because a car can drive away, you don't need a warrant. And you don't need a warrant if somebody yells for help. Then we can go in. And you don't need a warrant if government thinks they heard somebody yell for a warrant, then you don't need a warrant. And you don't need a warrant if you think a child's in danger, because then you can go in. And so, again, government will always find a way to wiggle in, and that's why it's so important, especially for younger generations, to be educated on the evils of government power and government growth. That's how they destroy freedoms. And they're effective at it because they got time on their side. These freaking shitty politicians will come and go, but they only have to get increments here, increments here. That's just like this Uvalde shooting with the gun right now. We got to do gun laws, and we got to go. They don't really care about the kids, and they don't care about gun laws. They want to chip away, and they're about to pass some expanded background, raising the gun limits. See, over time, somebody looks at this and goes, oh, that's reasonable. Oh, that's common sense. But over 50, 100 years, now common sense has become, nobody like New York, you can't own a gun unless you prove to us that you need one. And no matter what you tell us, we're going to say you don't need one. So we don't have to give out permits. So we basically get rid of your right. Just like Biden now is trying to do. He's trying to get Winchester to stop selling ammunition for guns that he don't like. He doesn't want AR ammunition for the M4 rifles that the military uses and police use. He don't want it sold to the pesky citizens. So he's, again, undermining the ability of a person to arm themselves, to defend themselves against criminals, because cops don't have a right, don't have to defend you. The Supreme Court ruled they don't have to defend you. This all ties together. This was an important case.
Carrying a firearm outside the home is a fundamental constitutional right.
Of course it is.
It is not some extraordinary action that requires an extraordinary demonstration of need. Petitioners here seek nothing more than their fellow citizens in 43 other states already enjoy. And those states include some of the most populous cities in the country. Those states, like New York, limit the firearms in sensitive places, but do not prohibit carrying for self-defense.
I don't even like the limited and sensitive places shit. If I want to carry a gun in a courthouse, I should be able to carry a gun. Cops carry a gun. If the government can carry a gun, then the citizen. Don't we always hear the government works for us? It's so bullshit when I hear that. People are just like, you don't get it. Government doesn't work for us. The government gets to make all these laws and they exempt themselves. In New York, cops get to carry anywhere. They get to carry at home. They get to carry in public, even when they're not on duty. Make the law to where it applies to government and then see how quick things change. Anytime laws apply to government, shit changes because they don't want to comply with it. They just want you pesky citizens to comply with it.
In any location typically open to the general public. I'm happy to continue by point.
Mr. Clement.
Clarence Thomas rarely asks questions. I mean, this guy will watch a lot. I've watched a lot of these Supreme Court hearings. He rarely ever asks any questions. So when he asks a question, it always intrigues me because he doesn't do it very often.
Sorry to interrupt you. If we analyze this and use history, tradition, text.
Now, just so you know, for people that aren't aware on how this works, there's an old saying that says most questions are statements in disguise. Because if I want to ask you what the temperature is, I go, what's the temperature? But if I want to make a statement, man, I got a question for you. It seems really hot and the trees are felling and the polar bears don't have any ice to float on and the water melting. And I mean, it's just the climate change is so bad right now. What's the temperature? See how the difference between why this thing is most questions are statements and disguises? Sometimes the Supreme Court will ask a question because they want them to make it clear. They know the answer. They know what they believe, but they want to know if you can make it clear. So that's what a lot of the questions from the justices do.
Of the Second Amendment, we're going to have to do it by analogy. So can you give me a regulation in history that is a basis, that would form a basis for a legitimate regulation today? If we're going to do it by analogy, what would we analogize it to? What would that look like?
Well, Your Honor, I suppose if you're going to reason by analogy, then you could, go back and you could find analogous restrictions relatively early in our nation's history about prohibiting certain types of firearms or having firearms or any weapon really, in certain sensitive locations. And I think you could reason in that way. Here, I think the reasoning works the opposite direction, which is you typically have a baseline right to carry for self-defense. And the only historical analogs that really restricted the right of a typical law-abiding citizen to carry for self-defense to the same degree as the New York law here were those laws, very few, typically post-Reconstruction laws, that purported to eliminate any right to carry.
Now remember, judges get to carry a gun anywhere. Cops get to carry a gun anywhere. Government gets to carry guns. Anytime governments makes laws against pesky citizens that they don't have to comply with, that's called tyranny, people. That's like having a king and a ruler. If I'm the king, my people get to avoid the law because I like them. You other peasants, you don't get to do things. Only my people do. That's what government is.
Openly or concealed. And those laws were essentially invalidated by every court that was applying an individual rights view of the Second Amendment. And those decisions, of course, were exhaustively considered by this court in Heller. And those decisions were praised for their understanding of the Second Amendment and the relationship between the prefatory clause and the operative clause. And equally important, those laws were.
I wanted to jump to the Heller decision real quick because I have a feeling they're going to bring this up a lot because these two are really connected. So the Heller decision is basically Second Amendment guarantees a right to possess a firearm independent of the service of the state or militia to use a firearm for traditional lawful purposes, including self-defense within the home. I don't know why they put within a home there. We wouldn't be having this discussion if they would have left out within the home. We wouldn't be having this discussion. But because they did that, the states and the left and the loony left were like, that's our opening. We can stop them carrying in their car or at schools or when they're not in their home. So now we'll stop them from carrying everywhere except their home because of this decision. That's the Heller decision.
Set forth by this court and singled out by this court as the very few restrictions historically that were comparable to what the District of Columbia was doing in Heller.
So if we look at you mentioned the founding and you mentioned post-Reconstruction, but if we are to analyze this based upon the history or tradition, should we look at the founding or should we look at the time?
Second Amendment shouldn't be about tradition. It should be about the fundamental right of the people not to be either tyrannically suppressed or their individual freedom suppressed by a government who's allowed to have guns, and therefore the citizens have less rights and ability to tell the government, no, I'm not going to yield to you like you're some sort of king. This isn't about tradition. It may be a tradition for America since we're one of the few countries that still allow gun possession. I mean, there's other countries, but we have it in our founding because we know what it's like to be under tyrannical rule when the redcoats were here shooting kids for throwing rocks and killing them. And it was okay because they were government, they had guns, and they didn't want the citizens to have guns to fight back.
Of the adoption of the 14th Amendment. So if we look, but if we are to analyze this based upon the history or tradition, should we look at the founding or should we look at the time of the adoption of the 14th Amendment, which then, of course, applies it to the states?
So, Justice Thomas, I suppose if there were a case where there was a contradiction between those two, and the case arose in the states, I would think there would be a decent argument for looking at the history at the time of Reconstruction, and giving preference to that over the founding. I think for this case and for Heller, and I think for most of the cases that will arise, I don't know that the original founding history is going to be radically different from that at Reconstruction. But I guess what I would say is I do think that's about where it stops. because the point here isn't to look at history for the sake of studying history. The point is to look at the history that's relevant for understanding the original public meaning of the Second Amendment and the 14th Amendment.
Mr. Clement, how could it stop there? In Heller,
we
made very clear that laws that restricted felons from carrying or possessing arms and
that was another way they started enacting gun laws, saying felons can't have guns. It started with violent felons that used guns couldn't have guns. And then over years, it's warped into every felon. And now they've even got it to where for a misdemeanor domestic violence, you can't own a gun. You see how the trickle-down effect of the main goal of government is always to disarm the public so you can't push back against a tyrannical government. The more government wants guns, the more tyrannical they want to be and they will become.
Laws that forbade mentally ill people from doing the same. We, basically put the stamp of approval on those laws, and those laws really came about in the 1920s, didn't they?
Justice Kagan, I think some of those laws in their current form took that shape in the 1920s, but I also think there was a tradition from the beginning for keeping certain people outside of the group of people that were eligible for possession of firearms.
What group of people is eligible? Would that be the American people? Would that be everybody in America? Is that the group of people you're talking about?
I think obviously there's a different tradition with respect to felons, in part because, you start at
Just for the record, I don't think felons should be exempt from owning a gun. If we say, if you do your crime and you do the time, you're a free man, you can start over. If that's what America's about, then we shouldn't restrict felons. It doesn't matter that we restrict felons any damn way. It's just another way for government to arrest more people and to keep the system going. There's a lot of felons that are probably more responsible gun owners than the idiots that go out and buy it on the streets and these young punk gang members that get guns. But we don't want to talk about that. We just want to limit the number of people any and every way we can from owning a firearm.
Time of the framing, and most felonies are capital crimes.
Correct. Back in the day when we were talking about this, a felony was a capital crime. Shit, you get a felony now for pushing your wife. It's a felony. I mean, it's just crazy how we made everything a felony. And that way, we get rid of the guns. And now that ain't enough. We want misdemeanors that you can't own a gun. We want drunk driving. There are states that won't let you get a gun if you've got convicted of drunk driving. You can't get a permit.
So, the need to disenfranchise felons for firearm possession was a little different at the framing. So I think you do need to make those kind of adjustments. But I think those adjustments can be made. I think really there are two reasons to at least be skeptical of post-1871 history. I mean, the first is I just don't really understand why it's terribly relevant in forming the original public meaning of the Constitution. But, of course, the second reason is it's just about that time that the collective rights view started to creep into the decisions of some state Supreme Courts. And I think so in Heller's a perfect example that this Court didn't absolutely stop its analysis in 1871, but when it looked at those later sort of post-bellum state Supreme Court decisions, the ones that relied on a collective rights view were given very short shrift. And I think that's the appropriate way to sort of deal with these historical analogs.
Well, I have two questions. One is on history. I mean, it's law of his history. In McDonald,
this guy always gives educational briefs in his question.
We had professors of history, ran departments in the English Civil War, and they all said the history in Heller was wrong. You've read the briefs here. I don't know. You read the briefs of the...
You should know. You should know that Heller wasn't wrong. But you don't like it. That's why you don't know.
The historian of the Air Force, and she says it's this way, and the other one says it's the other way. How are we supposed to deal with that? There's a good case. This is a wonderful case for showing both sides.
Excuse me, Justice Breyer. Is there a question in here somewhere?
So I'm not sure how to deal with the history. My other question is I'm not sure what New York does. We're talking here about outside New York City. New York says we have about 90,000 licenses to carry concealed weapons, or maybe it's 40,000, or maybe it's 10,000, but there's been no trial, there's been no proceeding, all it is dismissal on the so how are we supposed to find out, A, what the history is, which is my minor question, really. There's a lot of debate on that. But second, how are we supposed to know what we're talking about in terms of what New York does, since they say they...
Who cares what New York does? I don't care. They're left-wing idiots over there. I mean, you want to make the whole country, you want to base a decision on New York State? Let the states make their own rulings, but not on the rights of the citizens per our Constitution. They can make all their fines and permits and parking and all their other bullshit, but they shouldn't be able to take away the fundamental right of somebody defending themselves with a firearm, because the firearm is the greatest equalizer in human history. There is nothing better. If you're a weak female, if you're a disabled person, if you've only got one arm, if you are an easy victim for predators, the gun is the greatest equalizer in history, which, we call it a clue, is why government never gives up their guns.
Including to one of your clients. They give a license to carry a concealed weapon. So there are concealed weapon licenses all over the place. So what are we supposed to...
That's a bullshit statement. There aren't concealed licenses all over the place. New York, it's damn near impossible to get it. And if you do get it, you know somebody, or you pay a huge fine, or you're required to go to 6 months training. You're required to file. They have to do a background. It takes a year and a half. And by then you're dead. And they go, oh, we don't have to worry about this license anymore. He's dead.
To do about those two things?
Well, Justice Breyer, let me start with the major question, which is, because I think that's actually very straightforwardly answered, which is there's no serious question about the experience of the individual petitioners in this case. And they both sought unrestricted licenses, and they were both denied unrestricted licenses, notwithstanding that they satisfy every other requirement that the state has to be licensed for concealed carry. And so I'm happy to debate why the state statistics don't really prove anything particularly relevant, but I think they're irrelevant for a more fundamental reason. I mean, if there were a debate between the parties about whether 95% or 90% of the citizens of New York were denied their confrontation rights in criminal trials, but you had before you two individuals who were clearly denied the right to confront the witnesses against them, you wouldn't worry about the other 95%.
Bingo! Man, that was a slam dunk. Good for you, dude. Uh-oh, here we go. Here comes the idiot left. We'll come out of this.
Or the other 90%.
That's not really the way your brief is written. The way your brief is written is...
See, we don't want to talk. We don't want you to say things that make sense. I want to stick to your brief that now I can try and turn around on you.
To say, this is a regulatory scheme that deprives most people of the right to carry arms in self-defense.
I don't even know how they ruled. I guarantee you right now, she ruled against it. She's one of the three. I don't even know. I have no clue what justices ruled. She's one of the three. You can take that shit to the bank.
And your brief puts a lot of emphasis on that. Like, don't believe the state that they're going to really take seriously people's need for self-defense, because they always reject these licenses. If you had a bunch of statistics.
Once again, we have women in power that have armed guards, armed with guns to protect them. They can carry guns anywhere, and their armed guards can carry anywhere to protect them. And they want to argue that you should not have that same right because you are less worthy. How can anybody argue for these idiots?
Which suggests that the state is quite sensitive to people's need for self-defense and gives these licenses a significant amount of the time. You might think differently about the regulatory scheme, wouldn't you? I mean, that's the way your brief reads to me.
Well, Justice Kagan, 2 points. One is, I wouldn't feel any differently with respect to my two individual clients who were denied their right to exercise their Second Amendment rights. But more broadly, the reason I'm so confident that this regime is problematic on its face is because on its face, at least as interpreted by the highest court in New York, the requirement you need to show in order to carry concealed for self-defense, but not for hunting and target practice, is you have to show that you have a need for self-defense that distinguishes you from the generalized community.
I mean, just think about that for a second, people. I just don't have the right to defend myself in New York. I have to prove to the state, ask, beg, pay fees, wait months for them to review it for some dummy, and it's all up to interpretation on who reviews it, who doesn't, who agrees, who doesn't. I have to prove to them that I have the right or a need to defend myself. The fact that you live in New York, one of the highest crime rates in the freaking world, should be enough. You shouldn't need to prove anything. But not for a left-wing liberal. No, no, no.
In the general community. So New York's law on its face says that the only way that you can carry for self-defense is if you demonstrate your atypicality with respect to your need for self-defense. And that's...
Okay, I'm going to pause it here because I got to go get some more coffee. Okay, back. Here we go.
Because, look, Mr. Koch can. He has his license. He can carry it for self-defense under the license to and from work. And as you say, can carry it for hunting, target practice, etc. Concealed. And in your opinion, is it supposed to say you can carry a concealed gun around the streets of the town or outside just for fun?
Just for fun. This is the idiot. He voted against this too. I'm going out on a limb here because I have no idea how they voted. He voted against it, I'll almost guarantee you. Here's the three idiots. This one, and this one. There could be more, but I guarantee you probably these three. I think it was a 6-3 decision, so it's probably these three. I don't know if that's true yet. We'll see.
I mean, they are dangerous guns. I mean, so what's it supposed?
Cops carry it around. Government carries it around. You carry it around. Your security team carries it. Yeah, but Rick, they have training. Whatever. Freaking idiot.
Supposed to say?
It's supposed to be what New York says that they give to lots of applicants, at least in other counties, which is an unrestricted license, which basically means that somebody who has demonstrated to the state that they're of good moral character, that they have all the necessary training, whatever the state requires.
40,000 or 50,000 or 60,000 is not enough. You have to show you have a good moral character, and then if you just would like to carry a concealed weapon, which is a dangerous thing, as I said.
Which is a dangerous thing. Why is it dangerous? You can carry it. Cops carry concealed. Lots of states have concealed carry. There are plenty of people that carry. It's not dangerous unless you're a freaking idiot like you.
You can just do it. That's what that's, in your opinion, that's what you want. No restrictions.
Absolutely, that's my opinion. I'm trying not to say the F word. Idiot.
Well, certainly New York is entitled to have laws that say that you can't have weapons in sensitive places, in addition to whatever regulations
Right.
And New York has those laws, and we don't challenge those. What we're asking for, I mean, one way to think about it is we're asking that the regime work the same way for self-defense as it does for hunting. When my clients go in and ask for a license to concealed carry for hunting purposes, what they have to tell the state is they have an intent to go hunting. They don't have to say, I have a really good reason to go hunting. I don't have to say, I have a better reason to go hunting than anybody else in my general community.
Well, the difference, of course, you have a concealed weapon to go hunting. You're out with an intent to shoot, say, a deer or a rabbit, which has its problems. But here, when you have a self-defense just for whatever you want to carry a concealed weapon, you go shooting it around and somebody gets killed.
Oh my God, this is these left-wing people just drive me nuts. That's why people go, Rick, you need to reach across the aisle and get along. I cannot get along with a freaking idiot. An anti-Constitution, anti-American idiot. And that's what the left-wing liberal assholes are.
With respect, Justice Breyer, that's not been the experience in the 43 jurisdictions that allow their citizens to have the same rights that my clients are looking for. This is not something where we're asking you to take some brave new experiment that no jurisdiction in Anglo-American history has ever done.
Mr. Clement, you're talking about 43 other jurisdictions. And I suspect that when we get into those 43 other jurisdictions, that there are going to be a handful that are identical. The one thing that I've looked at in this history is the plethora of regimes that states pick. And that starts in English law, through the colonies, through post-Constitution to post-Civil War to the 19th century to even now. Those 43 states that you're talking about, most of them didn't give unrestricted rights to carry in one form or another until recent times. Before recent times, there were so many different regulations.
Yeah, and it was stupid. And what happens is crime gets out of control. And we elect people that don't make stupid rules like you're suggesting. And that's why it's changed over time, because the pendulum of government swings. And as government gets tyrannical and people push back, we elect different people, and then the pendulum swings back. And then when the liberals take over, because the Liberal Party used to be about freedoms, freedom to sing, freedom to throw your bra away, freedom to dance topless, freedom to smoke marijuana, it used to be left. It went so far left that people went, you freaking people are out of control now. So it goes here. Okay? So that's why the pendulum swings, because of idiots like you.
What it appears to me is that the history tradition of carrying weapons is that states get a lot of deference on this. And the one deference that you don't...
Now remember, the Supreme Court just asked Congress to give them more protection because they didn't feel safe. They can carry a gun, they have armed protection, and they wanted more protection for their family, their children, and their grandchildren. They want the government to protect them because they're special. They're the ruling class. They're the kings and queens, right? That's not what our country's supposed to be about.
Haven't addressed is, the question presented is, what's the law with respect to concealed weapons? In 1350, the British Parliament specifically banned the carrying of concealed arms.
Oh, great. We're quoting the freaking tyrannical redcoats that we had to die and fight to get out of our country. Yeah, that's who we're going to go back to. You freaking idiots drive me nuts.
In colonial America, at least 4, if not 5 states restricted concealed arms.
And they were wrong. And it's bullshit. It's none of government's business. What I do in my bedroom, what I do in my home, and whether or not I carry a gun, a knife, a sharpened pencil, a freaking cucumber that's been sharpened to a point. It's none of government's business. When I commit a crime, then government can claim that they have a right to act. Until then, leave the damn people alone, you freaking idiots.
After the Civil War, there were many, many more states, some included in their constitution, that you can have a right to arms but not concealed. You can go to Alabama, Georgia, and Louisiana, which are now more open, are more free in granting the right to carry guns, but they prohibited, through their history, concealed weapons, the carrying of concealed weapons.
Isn't it funny how the left likes the history when it suits their means, and there used to be restrictions, they want to talk about history. But when our country is based on a constitution, through history became the greatest country in the world, they think the Constitution is outdated. They want to throw it away. They want to raise the limit to owning a gun from 18 to 21, and they want to lower the limit to where you can vote when you're 16. So you can vote at 16 to elect an idiot representative, which the left loves, and then they can enact less gun laws, but they don't like that then. Just the most hypocritical people in the world, maybe besides religious people, is freaking liberals.
It seems to me that if we're looking at that history and tradition with respect to concealed arms, that there is not the same
Look at this.
requirement
This is a statement.
that there is
Let
in
me
the
just
home.
talk and push my opinion.
One of the things Heller pointed to was there were few regulations that prohibited the carrying or the keeping of arms in homes. But that's not true with respect to the regulations about keeping of arms outside of.
So let me get this straight, you freaking idiot. If government makes a whole bunch of regulations, then it must be good, and we must rely on those regulations to take away freedoms from the citizens. That's just freaking brilliant. You're an idiot.
Homes. Putting aside the prohibitions, regulations on sensitive places, regulations on the types of people, it seems to me that I don't know how I get past all that history.
Well, you don't get past anything because you're a freaking idiot. That's why. Idiots don't get past things. They just keep doing idiot things because they don't even know they're an idiot.
Without you sort of making it up and saying there's a right to control states that has never been exercised.
This is why the left wants to stack the court and do away with the Constitution. This is why we should have term limits. For left and right, nobody should be appointed for a lifetime. Because then the person that lives the longest, even though they're an idiot, gets to affect the country the longest. I don't like lifetime appointments to shit. Federal judges or the Supreme Court. Because once you get an idiot in, you're stuck with them for life and they can do too much damage over a lifetime.
In the entire history of the United States, as to how far they can go in saying this poses a danger.
Every state and news media that reported when a state has constitutional carry, that means you don't have to ask the government to carry a gun on you, concealed or open. You can just carry a gun. Every state that has made that, the left has come out screaming, we're going to have gunfights in the street, it's going to be crazy, people are going to be out of control. And when it doesn't happen, they have to go some other way. Well, let's get the felons, let's get the ammunition. Oh, it's a school shooting, that's what did it. We need to get rid of the guns because some idiot, some outlier did something wrong. Remember, freedom is hard. It's a lot easier to have tyranny because then the government can just make laws against everything. That's tyranny. Freedom is hard. Tyranny is easy. The left loves the easy way.
So, Justice Sotomayor, there's a lot to that question. I'll try to take it,
Because it wasn't a
sequentially
question,
if
it was
I
a
can.
damn statement.
I mean, let's start with concealed carry restrictions. I mean, it is true that during time periods where open carry was allowed, that some states did specifically restrict concealed carry on the precise theory that if we allow you to carry open, then if you're carrying concealed, you're probably up to no good. And Heller did exhaustively survey those cases. And what it concluded is that if a state allows open carry, then it can prohibit concealed carry. I suppose vice versa.
But you're asking us to make the choice for the legislature. We're only looking at concealed here.
We are not asking you to make that. And
well, yeah, you are, because you're conditioning history on a different fact.
I don't think we're asking for anybody to make that choice. In fact, the relief we've asked for is to have an unrestricted license because under New York law, as it currently exists, that's the only way that you can have a carry right for a handgun. But in framing our relief in the complaint, we framed it so that there are other relief consistent with the decision. So if New York really wanted to say, no, we have a particular problem with concealed carry, notwithstanding that traditionally that's the only way we allow people to carry. If they want to shift to an open carry regime, they could do that consistent with everything we've said here. Now, I don't think anybody expects that to happen because if you look at the New York law specifically, it's a law that prohibits the carrying of handguns except for permit holders. And then its provisions about permit holders speak specifically to concealed carry. So that's why we've framed our request the way we have. But what we're doing, I think, is completely consistent with the majority decision in Heller's analysis of the historical cases, which said that those very few states that tried to prohibit both concealed carry and open carry and so gave no outlet for the right to carry a firearm for self-defense outside the home, those were the laws that the Heller majority identified as being analogous to the D.C. restriction in Heller that was invalidated.
I do know that many of the laws conditioned or retain the right of the state to decide which people were eligible. And the historians to carry the arms, that you had to be subject to the approval of the local sheriff or the local mayor, etc. And during the Civil War, that was used to deny black people.
Which is exactly what they want now. They don't want to say it. Gun control is the most racist thing that I have ever heard yelled. Gun violence in black neighborhoods is outrageously high. Gun violence of black people killing black people is crazy. The left loves to confuse black people as needing them, and they're the only ones that care about them and keep voting for us because we'll protect you. They want to take away the right of good black people from defending themselves in the name of, we can't say that black violence and black crime is so out of control that we want to take guns from black people, so we just will say it's the gun's fault. We'll reterm the phrase as gun violence, even though a gun doesn't commit violence, no more than a lawnmower or a car or a rock. They don't commit violence. It takes a human act to do that, but we don't want to say that.
The right to hold arms. We now have the 14th Amendment to protect that. But
they keep talking about the 14th. That's basically, I didn't want to screw it up when I said it. The 14th Amendment states that forbids the states from depriving any person of life, liberty, or property without due process of the law, and from denying anyone equal protection under the law. And that's what red flags are. It's a due process. A due process means I have a right to confront my accuser. I have a right to go in front of a court. I have a right to state my side. And you have to make a ruling on what I did and why I'm wrong in order to take away something from me. That's due process. Red flag laws, I have to say I don't like you. You're my ex. You're a bad neighbor. I don't like your videos on YouTube. Therefore, I'm going to call in and say you're crazy and I don't think you should have a gun. And red flag laws allows government to come in and take away my right immediately. No due process. Red flag laws is a red herring. It is an absolute subversion of the Constitution, and it is horrible and bad no matter how it's worded.
Why is a good cause requirement any different than that discretion that was given to local officials to deny the carrying of firearms to people?
It's pretty simple. If you're not committing a crime, we don't care. If you use a firearm to commit a crime, we're going to come after you. You know what they do now? They dismiss all firearm charges, all gang members. That's the number one charge dismissed in these left-wing states with high gun control. They keep yelling on how much we hate guns. They dismiss. We have 250,000 people crossing the border every month just in Texas that we know about. I mean, just think of that concept. 250,000 people crossing the border every month that we know about, bringing guns, drugs, violent criminals across. And now as the violent rate goes up, they yell, we need to get the guns. They're diluting the population with people that don't understand our history, why we have guns, why it's incumbent upon people to be responsible with guns. And now they want to use that as a way, we need to get rid of the guns because there's more crime. And that's what's causing the problem. It's just bullshit.
People that they thought it was inappropriate, whether it was the mentally ill or any other qualification. That's how I see the good cause, as fitting in with.
They keep talking about the mentally ill. I've never known anybody that was mentally ill to, first of all, go in and try to buy a gun and say, I'm mentally ill. If they're mentally ill, they're going to lie. They're going to get a gun, and they're going to do something stupid. That should not be a reason to penalize every lawful gun owner and take away the guns unless your real goal is just to disarm the public so only you have guns, only you have protection. Just remember Uvalde School. 19 kids were slaughtered, one guy with a gun, while 19 government officials who get to carry guns, who had long guns and rifles and bulletproof vests and shields, and they waited for an hour to go in after the killing was done. That's what government wants when they get the guns, because then you'll be dependent on them for your safety and their protection. It's pretty simple.
Within that tradition.
So let me make a point about how it's so different from that tradition, but then also let me make a historical point. It's radically different to say that if you are a typical New Yorker, so you satisfy every other qualification, you're not a felon, you don't have any mental health problems, you've done everything else we've asked you, but you are typical in the sense that you don't have an atypical need to carry for self-defense. I don't think there's any historical analog to that. As to the historical examples, with all due respect, I don't think I read the surety laws the same way that you do.
That was an insult. Anytime someone says with all due respect before they say something, they're about to insult you or call you an idiot. That was an insult.
Those surety laws, which were only in place in a minority of jurisdictions, but nonetheless, I think they help us. Because those surety laws, first of all, start with the proposition that there's a baseline right for every person, every member of the people protected by the Second Amendment to carry. And what they do is if somebody essentially as a complainant can come into court and say that somebody has a propensity to use them in an offensive or violent way, then if you satisfy a neutral fact finder, then you don't automatically get to disarm that person. You put them to the choice of posting a surety, and then they can continue to possess their firearms.
Mr. Clement, in your opening, you talked about the right applying in any location typically open to the general public. I'd like to get some sense about what you believe could be off limits, like university campuses.
I don't believe that. There shouldn't be off limits. Who cares? Laws don't stop evil people. They only stop people that abide by the law. People who have jobs and pay taxes and can't afford to go to jail. People who don't have jobs, who don't pay taxes, who are criminals, they don't care if they go to jail. Therefore, they don't abide by laws. Therefore, laws don't affect them, and laws only affect honest people. I don't understand how this concept is so hard to grasp.
Could they say you're not allowed to carry on a university campus?
So, Mr. Chief Justice,
by the way, cops get to carry on campuses. As a retired cop, I get to carry on a campus because I'm in the government club, because I did my time and I got my concealed permit through the government because I'm a retired peace officer. Regular people don't. It's bullshit.
I think the answer to your question is yes. And I think that what I would say, though, first of all, is the language I was talking about, any location open to the general public, that's right from the license denial on Joint Appendix page 41. So there wasn't loose language on my part. That's right there from where we are told in capital letters where we cannot carry. Any location, all caps, typically open.
Well, what sort of place do you think they could be excluded?
Well, what does his opinion mean? Well, I don't understand why. It's almost like they're trying to catch him or see if he wants to give a little bit, or I don't understand. How does this matter what he thinks shouldn't be? He's arguing that the state shouldn't be able to blanketly disallow the carrying of guns because they don't think you meet a atypical requirement.
In other words, you can get a permit, but the state can impose certain restrictions. For example, any place in which alcohol is served.
Which is bullshit. Cops can carry a gun where alcohol serves. I mean, you don't think they drink at the Capitol? You don't think the justices drink when they got guns? You don't think they have a glass of wine at dinner and then get in their car with a gun or carrying a gun? Of course they do. But they're the ruling class. And you pesky citizens that buy into their bullshit and elect these idiots that don't believe in limited government, that's how you lose your rights.
Served. So they say you cannot carry your gun into any place where alcohol is served.
So absolutely bullshit. And actually in Texas, that's not the law. You can't carry a gun if the restaurant gets 50% more than 50% of their income from alcohol. But any place that I go eat dinner and they serve wine, I can have a glass of wine, I can carry, no problem. So that's not true either.
Mr. Chief Justice, I think probably the right way to look at those cases would be look at them case by case and say, okay, in this court in Heller, for example, said sensitive places include government buildings and schools.
Great. Government buildings have armed security, schools don't. Where are mass shooters? Where do crazy, mentally ill criminals go to where they know no one will have a gun? To schools. And the government yells, we need more gun control because they're shooting up the schools. It absolutely makes no sense.
I think those you can probably tap into a pretty good tradition. I think any place that served alcohol would be a tougher case for the government. I think we would have a stronger case. They might be able to condition the license holder on not consuming any alcohol. There might be a variety of laws, and we could have those debates. But
what about the football stadium?
Bullshit. Again, as a retired cop, I can carry at a football stadium, but you can't. Why? What is the difference? You're either responsible and you're not committing crimes, or you're a criminal and you're committing crimes. Why does the government get to tell you, even before you commit a crime, that you can't do something? It's bullshit.
I think, again, football stadium, you'd probably take it on its own and look to the historical analogs. But here's, I guess, if I could offer some general principles. I think there's two principles. One is, restriction of access to the place is something that I think would be consistent with the way government buildings have worked and schools have worked. Not any member of the general public can come in there. They restrict access. With or without a gun, if you're an adult that has no business to be in a school, you're excluded. So I think that's a factor that would support treating that as a sensitive place. A second principle that I would offer is these sensitive place restrictions really are a different animal than a carry restriction, because I think a true sensitive place restriction is not just going to limit your ability to carry concealed, but it's going to be, say, this is a place where no weapons are allowed.
So this sensitive place thing, the reason why they keep going here is they want to withhold the ability to restrict guns. They don't want unlimited guns, because then criminals will be safe or not feel safe. Citizens will feel safe. Citizens will be killing criminals, defending themselves. That will put government out of a job. Government will need less, and then they can't use the thing. If you don't vote for us and if you don't keep us, you're going to lose your ability to defend yourself. We're going to take that right away. Government wants dependent citizens so they can have government.
Whether they're firearms or other weapons, no weapons are allowed. And then the third point that I would say, and this is just an analogy, but I think it's a useful analogy.
And real quick, remember, government outlaws all weapons in prisons. Prisons are the most violent places ever, and people are killed and stabbed all the time. Even government can't carry guns inside a prison. And it's still the most violent place with deaths and crime. And they can restrict you and lock you up, and government has 100% control. If government can't keep a prison safe, how can anyone believe that by them taking away guns from good people will somehow keep you or your kids safe? It's just absurd.
I think the way to think about this is a little like the non-public forum doctrine in the First Amendment, which is you start with the place. And you try to understand, is this a place where, given the nature of the place, its function, its restrictions on access, that weapons are out of place? And if so, that's probably a sensitive place where the state can say.
But I think what the Chief Justice is trying to do is figure out how those cash out in the real world. So I'll give you a few more. New York City subways.
So, I think that
that's probably where you need the gun the most. See, liberals want to tell you we've got to keep good people who follow the laws. We have to have laws to stop you from carrying a gun in the worst places where you're likely to be assaulted. Because then you have to depend on us, and we can claim you keep safe. Even though criminals carry guns on subways, criminals carry guns in all sensitive places. It just amazes me.
The question of whether you could restrict arms in the subways, you'd have to go through the analysis, I think, and say, is there restriction on access generally? I suppose.
No, I got the analysis, all three parts of it. Like, how does it cash out? What does it mean?
It means it's bullshit. It's mean that laws don't stop criminals and laws don't stop crimes. If they did, we would have no crime because there's plenty of laws. Laws don't stop anything except honest people who abide by the law. And since they're not doing anything wrong in the first place, you're enacting laws because of what criminals do onto citizens that didn't do anything. It's bullshit.
I don't know how those are going to cash out in particular cases, because I think the way that you would normally deal with that is look at all the briefing we had in this case on the history of these various things. And so, on behalf of my individual clients, I suppose I could give away the subway because they're not looking to go, they're not in Manhattan, they're in Rensselaer County.
The Chief Justice started with universities, and you said that would be all right. Did you mean that?
No, I didn't mean it. He shouldn't have said it, and I don't mean it. I don't think they ought to be anywhere. Why are you penalizing good people that did nothing, their ability to defend themselves, when you know criminals like these school shooters will always go to places where you restrict good people from having guns?
Yeah, yes, I did mean that.
Because that's open for, anybody can walk around the NYU campus.
Well, NYU doesn't have much of a campus.
I would go back to New York, and I think you'll find that that's wrong. Similarly, the Columbia campus.
Columbia's got a campus, and I don't know whether they restrict access at all. And maybe, if they don't restrict access to parts of the campus, maybe those are parts of the campus where they wouldn't enforce the policy anyways. The point I'm trying to make,
but you can't say, there are 50,000 people in one place, a ballpark. There are 50,000 people in one place. They're all on top of each other. We don't want guns there.
That's bullshit. That's a flat out lie. Cops have gun there. Security have gun there. Off-duty police officers have gun there. Judges who can carry a gun have guns there. See, it's just, they want to frame this like they care about you, and it's not. It's bullshit.
That's, you couldn't, the city or the state couldn't do that?
I think they might well be able to, because again, you can't get into Yankee Stadium without a ticket. I'd have to understand many of these, I don't know every jurisdiction. I don't know enough about Yankee Stadium, but, a lot of these stadiums are not run by the government anyway. So if a private entity wants to restrict access, I don't know where the state action is for there to be a second.
Suppose the state says, no protest or event that has more than 10,000 people.
So a protest, let me get the logic of this freaking idiot. A protest starts out with 1,000 people. And it grows to 9,999. And I brought my gun, so I'm okay. But if another person shows up, now the government can charge me with unlawful carry of a gun. That's the idiocy of freaking gun laws.
I think that might be, trickier. Maybe they could justify that under strict scrutiny, but I don't think that would be a sensitive places.
But why not? I mean, I guess it's about the level of generality. All these questions that Justice Kagan's asking you or that the Chief asked you, if you concede, as I think the historical record requires you to, that states did outlaw guns in sensitive places, can't we just say Times Square on New Year's Eve is a sensitive place because now we've seen, people are on top of each other, we've had experience with violence, so we're making a judgment. It's a sensitive place.
So let me get this straight. Where there's going to be violence in a lot of people, you want to disarm, again, good people who follow the law. Meanwhile, the criminals ignore the law. They're going to bring their guns. They're going to do their violence, and you just make a bunch of victims. Ignorant.
So here's what I would suggest, that the right way to think about limiting guns in Times Square on New Year's Eve is not as a sensitive place, but as a time, place, and manner restriction. And that might be a perfectly reasonable time, place, and manner restriction. But I don't think that's the sensitive places doctrine as I understood it and obviously it's a brief reference in the Heller decision, so I may not fully understand it. But I understood that those were certain places where they were just no weapon zones all of the time because of the nature of that institution. And
no weapon zones. Raise your hand if you think criminals give a shit about a no weapon zones. They're facing going to prison by possessing a gun and using a gun to commit robbery or to kill people. And suddenly, the left wants to think that we have a no-weapon zone and we'll keep you safe. Prisons are no weapon zones. People are not safe in prisons. Government will never keep you safe. Don't believe the lie. I'm at an hour. I'm going to go ahead and make a part 2 on this, and we'll get back to this.